I'm Cecilia from the NCBFAA Educational Institute, and I'd like to thank you for joining us for today's presentation. Before we begin, I would like to clarify that this webinar is closed to the press and off the record. All information is for educational purposes only. Additionally, all attendees are in listen-only mode. However, you can submit written questions anytime, which, time permitting, we will address at the end. I'm excited to welcome Lisa Gelsomino, President and CEO of Avalon Risk Management, as our moderator today. Lisa was appointed to the 14th term of COAC in April 2015 and co-chairs the Turk subcommittee, which includes the ADCVD, Bond, Forced Labor, and IPR working groups. We are excited to have her and the rest of the speakers with us today, so without further delay, I will turn it over to Lisa.
Great, thanks Cece, and thanks everyone for joining us today. We have a big crowd, we're trying to get you all on, and we appreciate your interest in this topic. Before I introduce our esteemed panel, I just wanted to give you a little bit of background about the COAC ADCVD working group, what we do, and how this webinar came about. Our working group consists of the trade and different stakeholders, including domestic producers, importers, customs brokers, some of which are on this call today, different attorneys, sureties like myself. We also have all the different government agencies that participate, Department of Commerce, who, as we know, really sets what we call the policy for ADCVD, as well as U.S. Customs and Border Protection, which really enforces, all the different phases that the cases go through. And then, of course, we have ICE and HSI, and I think that sometimes gets that acronym, we have to update that, but this is where we get involved to the criminal side of things, and we have all of those agencies participate in our working group to really cover all sides of it. And then the working group meets monthly and will frequently come up with recommendations to improve things for the trade. I just highlight some of the recommendations here. These are really tools to help the trade comply. As you can see, we've been doing a lot more with CSM messaging to push out ADCVD information on new cases. I think in 2015 there were over 60 new cases, 2016 probably the same, so the more that you can get pushed out to you to introduce you to these new cases, the better. Department of Commerce has also been working very hard to update their website with different scope reviews. They have to go back to even paperless times, and they're trying to scan all that to make that more robust for you. And as you can see from these recommendations, a lot of what we've been doing is to work with the Centers of Excellence and Expertise that are now fully standing. They are really getting more intel on different industries. And of course, each of those centers has an enforcement arm that is working towards better enforcement on anti-dumping. And I think CBP has been doing a very good job trying to alert you of those enforcement updates. They have a whole section on their website. They do a quarterly trade enforcement updates. When you get a copy of this presentation, these are all live links where you can go for more information, but I encourage you to be reviewing those because they do highlight what cases they're auditing, where they're assessing penalties, where some things go wrong, and these can all be lessons learned. And lastly, we have been trying to, through CBP, make a much more robust website for you. You'll find that cbp.gov not only has information on its own enforcement issues, but has links to many of the different government agencies and their policies to help, and also a very robust, what we call ADCVD search page, where you can search for any active case and see what statuses is, see what federal notices were issued, see what instructions have been issued. So these are very helpful tools for you. So going into those recommendations came at the very last end before I was on the working group, and when I took over the working group for the 14th term, I really helped try to get a lot of those implemented, and we've been looking at a lot of different outreach, including webinars like this. And the first webinar we actually did was with Department of Commerce. That was really very well received. Just like today, we had a lot of attendees, and they went through every step of the phase, handling it from the investigation to the preliminary determinations and final and order. And you could see all the different things that they handle. That, of course, was another 90-minute session and something we're not going into detail today. But one takeaway from that is that they have established a Customs Liaison Unit, the CLU, and they have a very helpful call center that I would encourage you to call when you have questions that really involve commerce, remembering that CBP is really enforcing commerce's decisions. Also, there was another webinar that I did with Alexander Amdur from CBP that was on best practices, another 90-minute webinar. If you haven't attended that, that one was recorded, and you can see that. And as we look forward with the working group, we have been spending a lot of time, obviously, on the Trade Facilitation and Trade Enforcement Act, what we call TFTIA. And of course, one of the provisions under that is the Enforce and Protect Act, which is now called EAPA. CBP has done, the working group put together many recommendations about EAPA back in July before it was coming out into law. And CBP has done really all of those recommendations by putting out a very robust website that's very transparent, which is what EAPA requires. You can actually go into the e-allegation site, and there is a separate section where you can file an EAPA allegation online. And obviously, this is what we're talking about in today's webinar. What happens when things get reported as evasion? You know, what are the next steps? And things that we're looking at in the working group are, of course, the new executive order that was signed by the president. You know, what is going to happen under that, where CBP has to do more importer risk assessment, screening, bonding, things like that. You'll see as we go through this today what some of the red flags are that the agencies are looking at when it comes to evading ADCVD laws. And that was the reason why we obviously put this webinar together for you. So I want to briefly introduce our experts and welcome you to submit your questions throughout that we'll answer at the end. And also to myself, you have all of our contact information. Anything that comes up that you think should be discussed in the working group, anti-dumping working group, or future sessions of outreach, please let us know. So starting out with Heather Sykes. Heather is the National Program Manager for ADCVD and Free Trade Agreements, and I think we got it right here in Homeland Security Investigations. As you can see, this is a little bit of a long title. That's why we put it all out there for you. But many of you should be familiar with Heather because she spent over 7 years on the CBP side of the house with trade policy. Also, for the customs brokers on the call, you may have remembered her getting involved with, you know, Role of the Broker and doing a lot of the webinars for all of that. And she's also part of the ADCVD working group, and it's a real pleasure dealing with her, and I really want to thank her today because she has really put this excellent panel together for you for this webinar, which includes Crystal Oliphant from the ADCVD Enforcement Branch. She is the chief there. She works with Alexander Amdur and everybody on policy, and she's focusing on enforcement. And as you probably saw from her bio that we had distributed, she also has many years of service with U.S. Customs and Border Protection, over 25 years, I thought I saw, right? Close to. So, yeah, so we've got a lot of brain power here in this room. And she's going to discuss CBP's role in enforcing and referring things over to Homeland Security, and Heather's going to give a great update about them, and again, probably an agency that we don't know a lot about. We also invited Julia Peterson, who is the branch chief of broker management. Again, a lot of the customs brokers on the call should know Julia. I actually worked with her when she first came on board because she had a lot of IPR experience, and she did an IPR panel before she transferred to this role, and I know she's gotten heavily involved in the 111 rewrite and many different issues going on for customs brokers, and we thought her insight would be very helpful to see how brokers, you know, get pulled into maybe some of these investigations and, you know, what you can do about that. And she also has many years before joining CBP, lots of years in the private sector to give us good insight there as well. And then lastly, we brought in Department of Justice, since they obviously prosecute these cases. We have with us Steve Tosini. He's the Senior Trial Counsel at Department of Justice, and he's going to be talking about the role in ADCVD collection cases. I know he has some specific cases that he'll be talking with you about today. And also Christelle Clovers, right? Clovers, who's also a trial attorney at the Civil Division Fraud Section, and she's going to be focusing mostly on the false claims investigations, because we know that that is something you've been seeing in the press, something customs brokers have been seeing more often. And without further ado, I'm going to turn this over to Heather from Homeland Security Investigations to give you her updates. Move this phone down by you, Heather.
Thank you, Lisa. I appreciate the introduction. Thank you all for joining the webinar today. As Lisa said, I'm Heather Sykes. I'm with ICE, Homeland Security Investigations, and I'll tell you a little bit more about who we are in a moment, as well as telling you about the IPR Center, HSI's trade mission, and specifically the ADCVD program within HSI. I'll talk a little bit about common types of ADCVD evasion, explain HSI's criminal and civil authorities, and I'll discuss how HSI works with Commerce, CBP, and the Department of Justice. I'm also going to list some red flags that brokers and importers can look for to avoid being caught up in potential fraudulent activities that HSI investigates. So within the Department of Homeland Security, there are many agencies, one of which is CBP that you probably work with a lot. Another is ICE, U.S. Immigration and Customs Enforcement. So you hear about ICE in the news all the time. There are several directorates within ICE. One focuses on the enforcement and removal operations that you're hearing about a lot. There's another directorate called Homeland Security Investigations, or HSI. HSI is the principal investigative arm for the Department of Homeland Security. We investigate a wide range of domestic and international activities arising from the illegal movement of people and goods, both into, within, and out of the United States. The next slide shows our vision and mission statement. But HSI, generally, we have more than 10,000 employees. 6,700 of those employees are special agents who conduct the investigations that I just spoke of. The others are all supporting the mission of the special agents in some way or another. These employees work in over 200 domestic offices located across the United States and 62 international offices throughout the world. ICE has DHS's largest law enforcement investigative presence overseas. So we have a number of attachés in countries across the many continents. So all of HSI's mission sets have a nexus to three areas: border security, homeland security, and public safety. We enforce a diverse portfolio of federal laws, more than any other federal agency. So you'll see some of the types of investigations that we have up on the screen here. So everything from counterproliferation to child exploitation, child pornography, to identity and benefit fraud, human trafficking and human smuggling, narcotics enforcement, transnational gangs, financial crimes, and of course, intellectual property and trade enforcement. So within ICE HSI, one of the mission sets is the IPR Center. The IPR Center is located in Arlington, Virginia, and we're a task force-like environment with 23 federal and international agencies working together to promote national security by protecting the public's health and safety, the U.S. economy, our warfighters, and to stop predatory and unfair trade practices that threaten the U.S. and global economy. So the IPR Center is led by ICE HSI. However, we have deputy directors from both CBP and the FBI, and we have a number of other domestic partners, such as the Department of Commerce, FDA, the Consumer Product Safety Commission, and we have 4 international partners: Interpol, Europol, the Royal Canadian Mounted Police, and the Mexican Revenue Service, or SOT, which has 1 full-time person assigned to the IPR Center. So you're thinking, you know, this is a webinar about ADCVD. Why are you talking about the IPR Center? What does this have to do with us? The IPR Center has 2 main units within the IPR Center where there are ICE HSI personnel sitting in these units. One deals with IP and does all the intellectual property investigations. The other unit has 2 sections within it. One deals with outreach and training for the IPR Center, and the other is the trade program section, which deals with all of the trade enforcement programs other than IP, one of which is ADCVD. So this slide shows the priority programs for commercial fraud that we deal with. As you see, ADCVD is definitely one of them. We also have wildlife trafficking, tobacco smuggling, forced labor, health and safety. General trade fraud is general misclassification, valuation, mismarking, etc. So we're handling all of these in the one section, the trade program section within the IPR Center. And we're doing the program management at the IPR Center. I need to mention this. The actual investigations are being handled by the agents out in the field in both the domestic and international offices. So to enforce the trade programs with HSI, we work very closely with CBP and other agencies. And when we have a good ongoing investigation, then that can be referred to the Department of Justice for prosecution. And I'll discuss that a bit more in a moment. How do we initiate the cases, the investigations that we do? Most of them, I would say, come from referrals from CBP. Both in the field and through headquarters, and Crystal's going to talk a little bit more about that in a moment. We also receive specific complaints by competitors or industry representatives. We get a lot of informants, usually current or former employees that want to come forward and say, you know, my company is doing something they shouldn't be doing. We get leads from state and local regulatory agencies. Sometimes congressional inquiries could give us a potential lead, you know, something we don't know about that we start investigating. Sometimes we have strategic targeting initiatives, a national or a local program where we're looking at a specific commodity or we're looking at a specific area that could produce a potential lead. We do get some from foreign government investigations. A foreign government could come to us with something that they're looking into, and it could lead to an HSI investigation. And then also, when CBP receives an incomplete or inaccurate prior disclosure, those are sometimes referred to HSI for potential investigation as well. So when ICE HSI takes on an investigation, our primary objectives are the pursuit of criminal prosecution and the disruption and dismantlement of transnational criminal organizations. We do have other primary objectives beyond that, which are the assessment of civil penalties, working with CBP, the forfeiture of merchandise. We want to collect any lost revenue to the U.S. government. We want to assist in interdicting prohibited merchandise and regulating restricted merchandise as well. So ICE HSI gets involved in both criminal and civil prosecutions. And as I said, when we do the investigation, it is then presented to the Department of Justice for prosecution. Most of these are presented at the local level with the local U.S. Attorney's Office. And I want to make a point here that the criminal division and the civil division are completely separate. They don't work together. So if you're presenting a criminal prosecution, you need to go to the criminal division, and the civil needs to go to the civil division. And that's actually something a lot of people don't know, which is why I'm pointing it out here. Once the case is presented to the U.S. Attorney decides what criminal charges are to be brought against the defendant and constructs and prosecutes the case in local court. And criminal prosecutions, of course, carry potential jail time and fines, whereas civil prosecutions can result in monetary penalties. And the level of culpability is different. The criminal is beyond a reasonable doubt, whereas civil is preponderance of the evidence, which is a lower threshold. So when ICE HSI begins an investigation, we take into account prosecutorial considerations as well. You know, is this something that the Assistant U.S. Attorney is going to be able to take on? First, is there a violator that's in the United States? Is there an individual or a company that can be prosecuted in a U.S. court? We also look at the loss of revenue. A higher loss of revenue, of course, makes for a better case. We look at the violator's history. Do they have any history of penalty actions or other actions with CBP, or do they have any potential criminal history as well? We also look at the availability of civil remedies. Sometimes when there's a civil remedy available, that's the path that we want to take, you know, going through the penalty process rather than taking it criminally, depending on what the violation is. The technical complexity of the violation. And ICE HSI's ability, together with CBP and the Department of Commerce, to educate the U.S. Attorney's Office is sometimes a consideration. As you know, ADCVD cases tend to be very complex. The commodities that we're dealing with and the scope of the orders are quite complex as well. So it is difficult to educate the U.S. Attorney at times, and so this can be a consideration as well. Also care about the local or national economic impact and the generation of local interest and jury appeal of a potential investigation. For example, we had a successful HSI criminal investigation and prosecution in Pittsburgh recently on a ADCVD evasion on graphite electrodes. And so graphite electrodes are an input into the steel-making process. So because this was in Pittsburgh, there was general interest in that area because Pittsburgh is traditionally a steel-making town. We're looking at the availability of foreign evidence and witnesses. You know, are you able to obtain evidence in other countries? Are those other countries cooperative as well? Defensibility of violations. Can the violator come back and, you know, say why they did, you know, what they did wrong? You know, do they have some sort of story that they may be able to tell? And then, you know, can HSI develop witnesses to corroborate any documentary evidence that we have received? Those are all considerations in the case. So for ADCVD specifically, ICE HSI works closely with CBP and the Department of Commerce to conduct investigations. Our investigations are into non-compliant importers and other parties that attempt to circumvent the payment of the required duties. We're responsible for enforcing all of the ADCVD orders that are in place, all 300, and not sure how many there are at this point, 390 at this point. So we don't focus on, you know, steel or honey or shrimp. We do everything across the board, all of the commodities that are covered by an ADCVD order. And we recognize that criminals use many different schemes to evade ADCVD, which are dealt with on the next slide. So these are a few of the schemes that we have seen in ADCVD investigations. The first being illegal transshipment. We see this probably the most, where goods are being sent to a third country where the in order to mask the origin of that product. So if a product may be manufactured in China and it's sent to another Asian country, offloaded from one container into another, and then said to be the product of that other country that it went through. So that is an example of illegal transshipment. And then marking violations go hand in hand with that because the product is marked as country of origin other than what it really is. Incorrect valuation. A lot of goods, ADCVD goods, are undervalued so that they pay less ADCVD duty than is really owed. Misclassification. This is misdescribing the merchandise as something that's outside the scope of the order or misclassifying it in a harmonized tariff schedule number that may not be recognized as being part of the order. Failure to manifest. This is just general smuggling, you know, not even listing something as being part of a shipment at all. So you're not paying ADCVD on it. Sometimes the entries are filed as type 01 consumption entries instead of type 03 ADCVD entries, and therefore no payment is made. We're also seeing the use of shell companies more and more, where mostly shell importers are set up, and then when CBP sends that company a bill, they go out of business, they disappear, and the people behind those importers often have another importer already set up with an importer record number waiting in the wings to start importing the goods. And we're also seeing shell exporters now as well, so it's happening on both sides, and very difficult to prosecute or penalize any of these shell companies. And then the last one I call high rate, low rate. So this is, of course, the ADCVD orders. The duty rate is applied by the manufacturer or exporter or a combination of the two. So the importer can come in and say that the good was manufactured and or exported by a party other than the real manufacturer or exporter and receive a lower ADCVD rate than they really deserve. And so they pay less than they should. And sometimes the exporters or manufacturers are complicit in the scheme where they've actually agreed to allow someone, maybe they're taking some money from them in order to do it, and sometimes it's a case of identity theft. So these are the main statutes that are charged for ADCVD evasion. 542 and 545, I'd say these are the bread and butter. 542, false statements or acts, and 545, smuggling. We try to have the Department of Justice charge 545 whenever possible because this carries a prison sentence of up to 20 years. So this is what we try for as much as possible. If there's mail fraud, wire fraud, or money laundering involved, we try to charge those as well, wherever possible. And of course, the two money laundering statutes, 1956 and 1957, both 542 and 545 serve as specified unlawful activities to be able to charge these two statutes. So we're able to use them. And then at the bottom, the Marking Violations and False Claims Act are some civil statutes that we're able to use, and you'll have a presentation on False Claims Act in a bit. So I've been asked a lot about EAPA and what is the HSI role in the EAPA process. So the EAPA process is managed by CBP. So CBP conducts the investigations that are called for under the EAPA process. Those are separate from HSI investigations. However, CBP notifies HSI when they initiate an investigation so that we're aware, in case we have an ongoing criminal investigation, and we're able to coordinate that and work closely together throughout the process. And if CBP finds a potential criminal investigation throughout the EAPA investigation, then it can be referred to HSI for criminal investigation and possible referral to DOJ for prosecution. Okay. So I've been asked also a lot about potential red flags that brokers and importers can look for to avoid being caught up in a fraudulent scheme and therefore in an HSI investigation. And so I'm going to go through a few. I do want to note that some of these red flags, they're red flags, but they may not be a problem at all. Like, they could be just, this is how business is done. But it is something that we look for and that you may want to look at as well. The first of these, of course, is new importers or consignees. A new importer that has no history of importing. You've never worked with them before. Although this could be completely normal, new business is set up, it could also be a red flag for potential ADCVD evasion. Goods that are shipped from high-risk production areas. If you have goods, for example, that are manufactured in a country that does not do much manufacturing, for example, you see manufacturing in Hong Kong, and Hong Kong does not do much manufacturing, that's a potential red flag. Goods that are shipped from anonymous or false addresses. You may want to put the address in a Google Earth or other app to see, what is actually at that facility. If you find that you have a small house or a small storefront, but it's supposed to be a steel mill, something is wrong. When you see the same name used for both the sender and the recipient of the goods, that could be a potential red flag because someone's shipping something to themselves, and that's not usually how business, at least for large shipments, is done. Unusual payment terms are something to look out for. If you see cash payments, for example, or you see roundabout payments, and there's the payments received from an unknown entity that you've never worked with and you're not sure how they're part of the process, that may be something to look out for. International transactions usually involve pro forma invoices and or letters of credit. If you don't see either one in the transaction, there is no invoice, there are no letters of credit involved, that's a red flag as well. When you have a transaction where there are unknown intermediaries as part of the transaction, there are middlemen or agents that you don't normally see as part of the transaction, something that doesn't seem right, that's a potential red flag. Any late changes in the deal terms or the source of payment could be red flags. You have a deal already worked out, and then all of a sudden the person B is paying you instead of person A. That's a potential red flag as well. We look at LDP and DDP transactions as potential red flags. I know that this is normal course of business, and a lot of companies are having their goods delivered LDP or DDP, but this is a potential red flag for HSI in an investigation. Unusual shipping routes doesn't follow the they don't follow the patterns where the ships usually go. You know, things are being offloaded in countries where they normally wouldn't be. Something to look for. Packaging that's inconsistent with shipping. Suppose you have a large piece of equipment that would normally be shipped without being wrapped in any way, and all of a sudden you're seeing it shipped and it's wrapped, or something that's packed in a way where it might be difficult for CBP to examine the shipment. That's a red flag. Inconsistencies across documents, including the shipping documents. You know, one document says it's manufactured by person X, the other one says it's manufactured by person Y. That's something to watch for. As well as inconsistent marking. Suppose the box says country of, country X, and the actual packaging of the product says country Y. That's definitely a red flag. Also, products that are inconsistent with a company's business portfolio for both the manufacturer and the importer. If you're seeing something where an importer is bringing in products that it just doesn't normally seem like something that they would bring in, that's potentially a red flag. And the last one I want to discuss is that we've found companies that seem to import only commodities that are subject to ADCVD. That is definitely a red flag. So if we see a company that is suddenly importing just shrimp, honey, garlic, wire hangers, and candles, that's definitely something that we watch for. So. Anyway, so thank you very much for listening. I hope you learned something today. Feel free to contact me at any time. This is my information. And I believe we're going to hold all questions to the end so all the speakers have a chance. So thank you.
Thank you, Heather. Next up, we have Crystal Oliphant from CBP. Crystal?
Good afternoon, everybody, and thank you, Heather, for sharing that overview with us. Appreciate that. That's very helpful. Even though I work with you, it's always great to hear what we're doing to enforce ADCVD. Good afternoon. I'm Crystal Oliphant, and I work for U.S. Customs and Border Protection in the Office of Trade. We have an Anti-Dumping and Countervailing Duty division, and I am the branch chief in the enforcement section in that office. And pretty much my office, we initiate discussions with petitioners when orders are in the preliminary stage. We request meetings so that CBP can receive commodity-specific information and hear of any concerns that they may have with goods believed to be entering the United States at unfair low cost and subsidized by foreign governments. Further, we also receive allegations and intel from industries, and we coordinate with CBP's Anti-Dumping and Countervailing Duty National Targeting Center and the Centers of Excellence and Expertise throughout the United States to enforce ADCVD orders that are issued by the Department of Commerce. So today I'm going to discuss the partnership we have with ICE, HSI, and the referral process. And since ADCVD is a priority trade issue, our organizations, we work closely together, ensuring transparency by pretty much sharing relevant information that can make all the difference in the government's ability to protect national economic security. Okay, so I can't stress enough, again, ADCVD is a priority trade issue, and CBP's role is essentially to protect U.S. national economic security at our borders. Further, we ensure that we level the playing field for U.S. manufacturers by collecting ADCVD duties on imports sold at unfair low prices and subsidized by foreign governments. And last, we facilitate legitimate trade and enforce ADCVD laws. So before I get started with our partnership, I just want to set the stage and point out the agency responsible for administering authority, that has the administering authority for ADCVD in the United States, and that's the Department of Commerce. And since they have that authority, CBP, we pretty much follow their instructions and their guidance. But essentially what we do is we collect ADCVD duties on goods imported into the United States and subject to ADCVD orders issued by Commerce. In fact, at this time, the last time I checked, the number of ADCVD orders, it's over 390. So I think we're about 392 the last time I checked in April. So that number is rising as we speak. Right. Now, from a headquarters standpoint, DHS, CBP, Department of Commerce, and ICE HSI, we communicate and collaborate on a regular basis, whether it's during meetings or also just keeping in contact on relevant information pertaining to ADCVD. Further, CBP and ICE, we both being DHS components, we maintain joint efforts and activities that are focused on ADCVD. And what we do is we enforce and target goods imported into the United States and subject to ADCVD duties. Further, we also engage with the trade community, and we have outreach efforts in which we, for instance, you have industry meetings on a regular basis. We also attend seminars provided by industries, and we also do visits to the facilities and look at the production activities at these facilities to assist us with enforcing ADCVD. And next, we also share pertinent information, and I'll get into the referral process shortly. But I'd like to stress that accountability is a must, so we make sure we plan and we report any activity that we do. We have to make sure we can report those results to Congress. Okay, so we have our CBP personnel throughout 10 centers of excellence and expertise throughout the country. And then at headquarters, we have our Office of Trade and our NTAGs throughout the United States. We all support ICE HSI investigations. Okay, so CBP will provide our findings to HSI. However, they ultimately decide what to investigate. ICE HSI, they're being the lead DHS agency for trade criminal investigations, we pretty much just keep them abreast of any ADCVD evasion leads that could potentially lead to an investigation. So CBP, we refer HSI, refer leads to HSI, whether it's at headquarters. Also, our NTAGs can refer something to be investigated to HSI, and also from the field level, we have the centers. And as Heather mentioned earlier, the majority of those are coming from the field level, and they collaborate with their counterparts, HSI, throughout the country. Okay. I'm still in the last bullet. Okay, so referrals can be leads or tips, which can be based on CBP's findings. Also, they can be provided by industry and even the Department of Commerce, and Heather got into other entities that can provide them those leads. But those are the ones that I'm more familiar with. Okay, so CBP, we send the leads to HSI, and pretty much what they do is they track those leads. So anything that they decide to open, and they also track the outcomes of those investigations. And further, CBP and HSI, we're pretty much currently working to implement a tracking mechanism. So whenever those leads are provided, we can be in a better position to account for those numbers and report those outcomes to Congress. And that concludes my portion of the presentation.
Great. Thank you.
Thank you.
Next up, another speaker from CBP, we have Julia.
Hi, this is Julia Peterson. I am the branch chief in the broker management branch, obviously. I work in the Office of Trade under TRLED, which is Trade Remedy Law Enforcement Division. I want to speak briefly today about avoiding risk management and avoiding getting involved in ADCVD issues. So a little bit about risk management. What is risk? And it's the degree of exposure to the chance of noncompliance. It is really the broker's responsibility to keep this in the forefront of their mind. You don't want to get involved in ADCVD issues, and I think that they're out there, and it is your job to think about who your clients are, educate them, and avoid risk. Okay, so here are some potential triggers you should be aware of, and I think that Heather has spoken to this in depth earlier as well. An importer that lacks a continuous bond on file. A recently established importer with a bond at the minimum amount. An importer who's recently incorporated. Freight forwarder signing a POA. We know a POA should be between a broker and an importer. An importer asking the broker to act as the importer of record on an ADCVD entry. Be sensitive. Okay. We ask that you educate yourself. Know about specific commodities you oversee. This particular, you want to go to the next page? This U.S. ITC website, very good site, teach you about commodities and avoidance. Know ADCVD project liability by country. Again, information can be found on the U.S. ITC site. Know the general ADCVD case life cycle from start to end. Be mindful of existing case orders. Be aware that Commerce can retroactively issue instruction under critical circumstance cases, specifically market flooding. Thing may not have been subject at entry, but it may be subject to it at a later date. Use the ADCVD site. See what's available out there. Educate yourself. Educate your clients. As mentioned earlier, ADCVD violation is a priority trade issue. ADCVD violation is addressed in executive orders. Educate your clients about ADCVD. Okay? Importers face increased duty assessments even years down the road. Importers' product can become subject to ADCVD orders later. ADCVD evasion is a crime. Require information from the importer. One of the first filters you should apply to protect your brokerage is the subject being imported, is the product being imported subject to ADCVD? Review the invoice details. Make sure you understand what the client is trying to import, and know your commodities. I can't overestimate the quality of the US ITC site and understanding products. Know your manufacturers. Are they seeking special use of rates? Should you come under investigation, cooperate. Okay. Records must be maintained for a minimum of 5 years from the date of entry. Respond to requests made by CBP under records regulations. 19 U.S.C. 1509 provides CBP and ICE with summons authority. Should you receive a summons, respond within the required time frame. You may be required to produce records or give testimony relating to records. Records can be kept longer than 5 years, and they can be summoned. Failure to comply with a summons can result in contempt of court. Okay. Here's the kind of information that you may be asked to produce. Any records required to be kept under 19 CFR 163, invoices, packing lists, plating, airway bills, payment records, email correspondence, power of attorney. Records, make sure they're readable and understandable by you. Just briefly, remember, ADCVD compliance is law and a PTI. No signs of prospective importer ADCVD risk. Protect your brokerage. Your commodity. New ADCVD cases, provide accessibility to your staff, educate your clients. Keep in mind, increased duty assessments can occur years after entry. Again, require full invoice details. Don't accommodate an importer if you don't understand what the product is. You are responsible. Cooperate with investigations, keep records, make them available, ensure your POAs are vetted and maintained. Thank you.
Okay, thank you. Next up, we have Stephen from Department of Justice, and you're going to talk to us about, what do you got on your list there?
I'm going to talk about customs penalty enforcement at the Court of International Trade. Hello, my name is Steve Tassini. I'm an attorney with the Department of Justice here in Washington, D.C., and among my areas of practice, I handle customs penalty matters under 19 U.S.C. 1592 at the Court of International Trade in New York, as well as broker penalty matters under Section 1641. And both of those statutes are very relevant to customs brokers because customs brokers can be penalized under both statutes. I'm going to focus my talk on Section 1592 today, and the important thing to remember is that the prohibition in Section 1592 is extremely broad. What the statute says is, no person by fraud, gross negligence, or negligence may enter, introduce, or attempt to enter or introduce any merchandise into the commerce of the United States by means of any false statement, or may aid or abet any other person in such a violation. And that language is extremely broad. And in the Trek Leather decision, the Federal Circuit made very clear that the word introduce goes far beyond the actual process of making an entry with customs. And there, I'll read the first sentence from that decision. Mr. Shadadpuri, who was the principal of the corporate importer of record, transferred ownership of merchandise while it was in transit to the United States to a company he chose to be the importer of record. He also furnished to the hired customs broker invoices that materially understated the value of the merchandise, thereby reducing the calculated customs duties. Then the court held that by these actions, Mr. Shadadpuri introduced merchandise into the United States commerce by means of undervaluation within the meaning of Section 1592. So the statute's incredibly broad, and customs brokers themselves can find themselves on the hook for a Section 1592 violation. And customs' regulations also explicitly recognize that that brokers can be liable for penalties and lost duties under 1592. And in fact, if you look at 19 CFR Part 171, Appendix B, there's a whole subsection involving customs broker liability under Section 592. So I guess the take-home from that is that although there have been very few, if no cases, none that I have filed in court involving a customs broker defendant, it is a very real possibility. And that's something that the customs broker should always be keeping in the back of their mind when they're signing on the dotted line or when they are advising an importer about a course of activity. I'll turn it over to Christelle Clovers to talk about the False Claims Act.
Okay. So, thank you. I guess I would just preface my remarks by saying that what I'm about to say represents or reflects my views and not necessarily the views of the Department of Justice.
And Steve here, exactly the same for me. I forgot to say that in the beginning.
Of course, the attorneys remember to say
So I am an attorney with the Department of Justice in the Civil Division.
in an office that deals primarily with the False Claims Act. And so the False Claims Act is actually an old statute started during the Civil War, basically to combat procurement fraud, guns that didn't fire, flour that was really sawdust, that kind of thing. And it's been updated over the years. But the idea is still to get at false claims to the government for money. And then, so that is still the bulk of our case, are kind of the direct false claims requesting money from the government. But one of the provisions, and I'm just going to read it since I do not have slides for you here, but the reverse false claims portion of the False Claims Act is 31 U.S.C. 3729 A1G. And it says, any person who knowingly makes, uses, or causes to be made or used a false record or statement material to an obligation to pay or transmit money or property to the government, or knowingly conceals or knowingly and improperly avoids or decreases an obligation to pay or transmit money or property to the government, is liable to the United States government for a civil penalty, plus 3 times the amount of damages which the government sustains because of the act of that person. So as you can see, it's a fairly broad provision in that it involves people that have an obligation, people that cause another to conceal the obligation. So it's not just own acts, but also causing other actions that relate to this obligation. And there's also a conspiracy provision of the False Claims Act as well, if you conspire in trying to violate one of the provisions of the False Claims Act. So knowingly here, too, is an important portion of what we do. And knowingly has a broad definition, again, under the False Claims Act. It's not just actual knowledge. It also includes acting in deliberate ignorance of the truth, kind of the ostrich head in the sand kind of defense, or acting in reckless disregard of the truth. So it does not require proof of specific intent to defraud. So we have seen at DOJ, we've seen an uptick in the last 5 or so years in the number of False Claims Act cases involving customs. Just to kind of give you some background on the False Claims Act, it basically allows a whistleblower, someone we call a relator because they're relating facts to us and allegations, to file a complaint against defendants in district court. It's filed under seal, so that, and then they serve it on the Department of Justice. And so we have a chance to look at their allegations, to kind of decide, assess, see if they have merit, and we have a number of investigative tools we can take during that time to try to decide if this, both if the allegations have merit and if it's something that the government wants to kind of intervene and take over that case. If we don't intervene, the relator can still go forward. They can bring the case on behalf of the government, essentially. And so we'll kind of keep an eye on that litigation, but it is them running the show there. They can get discovery and arrest. They also, a relator gets a percentage of the recovery, usually. Usually 15 to 25% of what the government recovers goes to the relator. So you can see that's a good incentive for people to come forward. We do see, as Heather was talking about, kind of the insiders, the people that work in the companies that are coming forward. In customs cases, perhaps more often than others, we see competitors coming forward that have enough information to kind of piece together and file, trying to both get some money as a recovery and stop competitors from committing fraud. So
again, these are filed under seal for an initial 60-day period, but there are further extensions for good cause, and they're usually extended for quite some time as we investigate. When they come in, we look at it, we kind of make a decision, again, whether it's going to be handled by main justice kind of folks or it's going to be out with the U.S. Attorney's Office. So you'll have, depending on the case, it could be either or both. And basically, once we get these complaints in, we notify then the agencies. So we notify CBP, HSI, Commerce if it involves ADCVD, and the criminal division also gets a copy, so they can decide if this is something they want to look into from a criminal perspective. And there can be parallel investigations with criminal. Everyone kind of stays in their lanes, but there is parallel investigation. So basically, we put together a team at that point. Usually, we'll have an HSI agent. We'll work closely with CBP attorneys, Commerce attorneys, and sometimes CBP auditors get involved. It's just kind of whoever makes sense for that case, that team. And we start investigating. And so the mechanisms are oftentimes going to be, it could be CBP document requests, but more often under the False Claims Act, we have something called a civil investigative demand, a CID. It's essentially a subpoena. And so we will send those out to people we think have information. So not necessarily the named defendants of the case, but often, would include the broker who might have some information for us and may not be a named defendant. And so that will request a number of different documents. It also allows us to request interrogatory answers and to request depositions. So those are very important tools for our investigation. So we look at all of that. We've had a number of different cases involving the different kind of schemes that Heather touched on too, I think. We've had cases involving where the wrong country of origin is put on, and it doesn't necessarily have to be, again, we're not talking actual knowledge. It doesn't have to be that they're outright lying. It can be, a substantial transformation question where they're bringing a product into one country, doing something to it, and claiming that that's substantially transformed it. And, we're going to look at what did they know? Did they have reason to believe that that really didn't substantially transform it, and they're, cutting corners here trying to avoid the AD or CVD? We've had cases with just, straight transshipment going through another country, repackaging it, undervaluing, multiple invoices being, you see the real one, and then you see the one that's submitted to CBP. And then misclassifying, certainly, what the good is. And so we'll do that investigation, make a decision. We're usually going to talk to the defendant before we intervene. If we're thinking we might intervene, we want to hear their side of the story. It might open up a road to settlement discussions, and then we'll make a decision. So as I said, we've had a large increase, I think, in the number of these types of cases. I think it's an important tool and a way to combat fraud. Again, treble damages can be a lot of money you're talking about. We also have penalties for each false claim, or in this case, I think it would kind of be every false entry form is going to come with a penalty of around $10,000 to $20,000 per. So that can add up if you have a lot of them. And so I think just last year, I think we had about $50 million that we recovered under False Claims Act customs cases. And I think that's about all I have.
Great, thank you.
Great overview, and it's going to leave plenty of time for questions. Just to wrap up, I gave some links here that summarize. I started out mentioning that the Department of Commerce really sets the policy for ADCVD, and so here's some links to a lot of their key sites where you can get information as well as CBP information. And I think we want to go ahead and open it up to questions. So if you'll just be patient, we're going to pull up your questions that you have submitted. And I guess while we're just waiting to do that, I know I can throw one out there that for the customs brokers kind of in the audience, they said that, recently they have felt like they've been getting contacted more often. It's their importer who maybe has been brought into an allegation because of the False Claims Act, whatever the case may be, and a broker is being requested for information. You kind of touched on that, but in some instances, brokers have said they have settled these cases because they fear that being involved in them was going to be very costly. Can you maybe give some insight into maybe some of the cases you've seen working with brokers, what other guidance you can give to them?
I mean, I would say work with us. I think talk to us. I think that everyone's going to have that dialogue before they decide to settle a case. But, we're asking for certain documents, and I think we're willing to work. If it's, a small company that has a limited budget, we can, work on how maybe those documents are produced, try to get at a way that's not too burdensome. But those are records they're required to keep and produce, so I think that we would expect that that can be done without forcing them into some sort of settlement that doesn't make sense.
Okay.
And with us, our Section 1592 cases are different than the False Claims Act cases in that you receive a referral from Customs after a long administrative process has already occurred. But nevertheless, one of the main defenses that importers will raise in a 592 case is they'll blame the broker, especially in a misclassification type case. So we always have to get the broker side of the story. So we ask the broker for any records. Are there any emails between the broker and the importer where the broker provided advice? And then we'll take a deposition of the broker. We're not trying to impose any sort of undue burden on the broker, but that's simply our due diligence in handling a 592 case.
And I think the brokers are aware from the standard regulation, 19 CFR 111, that records have to be maintained.
What happens in dumping? We referenced this because they don't have to maintain them for 5 years, and being a surety, I know we have claims that don't even liquidate sometimes till 10 years later. What happens if they don't have those records? They have no exposure under the law because they only have to keep them for 5 years, right? There's no separate provision for dumping. Some dumping cases could take much longer than 5 years. You haven't run across that? Okay.
Well, we've run across, I've received plenty of referrals where entries are more than 5 years old. And regardless of whether the broker violated, or did not violate any sort of record keeping, we're still going to ask the broker what they know, and we're hoping the brokers will cooperate with us, and we've never really had any problem with recalcitrant brokers.
Okay. So we do have some questions that came, and the first one, I think probably for you, Heather, is there a list of red flag items available? I know that you read them, and I actually took my own notes while you were doing that. But is there any kind of published list or anything like that?
No, we don't currently have a published list. So hopefully you were able to get the notes. I'm happy to have a conversation with anyone after, and try to go through it with you. But.
Right. Okay. Thanks.
I imagine those are evolving.
Yes.
So.
It's not a set list. It's more, these are things we've seen that you may want to watch out for. But yes, it's ever growing. I'm sure there are a lot more than what I listed as well.
Yeah, and we really appreciate you guys being on the enforcement side. It's very hard to balance how much do you communicate because, you have obviously sensitive information. So we appreciate the information you were able to share today. And I think the customs brokers, as this arm of, working with the importers, many of them on the call today, it's helpful for them to, hear about this information so that they can, be a force multiplier and see what they should be looking for in these cases. So we have some other questions that came in that probably involve more of commerce input, but let's see. Can you please provide the scope of the 232 investigation into aluminum imports? I don't think that anyone here can answer that question, but certainly we are going to do a written Q&A follow-up, and we also know who submitted these questions, so we'll come back to you and provide that information and then incorporate it into the final write-up. One of the next questions was, will CBP continue to post CSM notices regarding ADCVD on scope ruling similar to the one posted on the Ethan Allen scope ruling? Actually, I can answer this for you. Again, it's a commerce, but we've talked about this on the ADCVD working group. We have not gotten to the point where every scope ruling is pushed out via CSMS. Sometimes they are done for very important cases, as this one or others, and that's still part of the process. And I think I mentioned in the beginning of the call that Commerce is still trying to upload all of the scope information into their site. And then once that's done, you know, on a going forward basis, seeing how they can push more information out. But any scope ruling, anything that Commerce does, please keep in mind that it's always available by Federal Register notice and can often be found as well in CBP's search site. I often go into the search site and I look by commodity, and you can sort by scope ruling, you can sort by different phases of the investigation to kind of search the information you're looking for. And if there's any additional information we can incorporate into the written Q&A, we will do so. You will receive a PDF copy of this PowerPoint presentation. That was one of the questions. That will come out with the survey after the webinar, and we appreciate your feedback and other information that we could include going forward. As I mentioned, this was the third kind of webinar we've done in the ADCVD series, and we're always looking for your input to provide more guidance. Another question was, how does a product become potentially ADCVD after importation and filing of the entry? Well, that's a loaded question. Someone want to take it?
Okay. Well, there's a couple ways. The first way would be during an investigation, an anti-dumping or countervailing duty investigation. Commerce really issues two determinations. First, it issues a preliminary determination, then it issues the final. And normally, it only begins imposing duties for entries that come in after the preliminary determination, if it reaches an affirmative determination. But at the preliminary stage, if Commerce determines that there were what are called critical circumstances under the statute, maybe a surge in imports, it can go back 90 days and say for entries made going back 90 days from the date of the preliminary, we're going to collect cash deposits for those duties going back to that period. So that's one way. And the second way might be as if you're importing from an exporter during a period of review later on during the pendency of the order, and that exporter has a zero rate. Well, if Commerce reviews that rate, the rate might go up. It might go from 0 to 10 to 100. And if that's the case, when those entries liquidate, you'll receive a bill from Customs for the duties, and that could be years after you made entry.
Yeah, and to just expand on that maybe just a little bit, many of you probably have seen in the news, it's a pretty high-profile case, the softwood lumber. And I think many of you are probably familiar, at least as a surety, we know the softwood lumber cases back in the early days, and then of course this agreement was reached, and then of course the agreement no longer reached, and this investigation is starting all over again. And so what happened in this scenario, I want to say on April 24th, I believe, Commerce published preliminary findings, and they specified in those findings certain shipper rates averaging around 20%, and then if you didn't have your own shipper rate, you go to the all others rate, which was also around 20%, and some shippers had lower rates of 3%. So during this preliminary phases, those cash deposits need to be posted at the rate that is provided. Commerce also declared critical circumstances, so they must go back 90 days retroactively from April, I think 26 actually is when the date of the federal notice was published. So back to January, is when those importers need to be posting cash deposits retroactively. Now, if they don't post those cash deposits retroactively or going forward, they will be subject to non-failure, to pay duties, just like any other duties. They can risk liquidated damage claims, plus CBP can come after them for those deposits. Those deposits are capped during the preliminary phases until an order is issued later in this year, your final findings and order. Those rates could change, and at that time, they have to start posting those cash deposits. But then, as you mentioned, if it goes into administrative review and the annual period of review, those rates can change, and they do so in a retrospective manner. And that is part of the challenge with our U.S. system, and that's why you are constantly seeing, a fluctuation in the rates. So I guess the next question is, are there any risks involved to the importer for importing ADCVD products and paying the additional duty and taxes to CBP? I'm not sure I understand the question. I mean, obviously an importer has risk when they bring in ADCVD products, because even though they pay the cash deposits at the time of entry, those are only deposits. They are not the final duty due. And so if they don't understand that, and they are caught in a period of review that 3 years later changes their rate, either because their shipper didn't comply, or they change shippers, or there's many different things that could happen. They could have had a very low rate and then suddenly go to a high rate that they didn't contemplate in their sale price, and probably unlikely be able to afford that. And that's certainly something we see all the time on the surety side, is that even though the importer may not have committed fraud, they did not understand their obligation and couldn't afford them and put them out of business. So to answer your question, I do think there is risk in dumping because it can be volatile, it's not certain, and if you don't understand what you're getting into the first time you bring in a shipment, you are probably going to run into some challenges. If you have anything else to add to that.
One other, just my personal view, one other red flag is a super low cash deposit rate, and that would fit in well with, say, the identity theft or other potential means of violating the customs law. Also, if you have a very low cash deposit rate, the domestic industry might attempt before the Department of Commerce to raise that, and jack that rate up. So if you're getting a zero rate, you really should not count on having a zero rate when the entry finally liquidates.
Yeah, exactly. There's a lot of confusion about that 0% rate. Doesn't always mean it'll be zero. So we have another question here. If CBP disagrees with the amount of ADCVD you paid upon entry and sends either an entry rejection or a CBP 28 or 29, how much time do you really have to pay CBP the difference CBP says you owe? Until liquidation? The CBP one.
That's a payment question?
I can take this for you. Okay.
Oh.
Yeah.
Yeah, because either, if I'm not.
So the issue really happens through the process. There's a 28 request. Obviously, that's a request for information, and that's going to specify how much time they need to respond. CBP then reviews that information in the 28 request, and if they proceed, they're going to issue a 29, which is to take action. And that 29 means they're going to take action, and they're going to liquidate the entry at that action, because most of the time anti-dumping entries are suspended until liquidated. And so what happens then is when Customs liquidates that entry, an increased duty bill will generate, and just like any other increased duty bill, whether it's anti-dumping or not, payment is due within 30 days, and if payment is not received within 30 days, interest will begin to accrue, and the importer will have 180 days to protest that bill if they feel that they don't agree with it. And that's the standard process that it would go through. Okay, are there any general time frames for open and closed cases? I want to say you're talking about anti-dumping again, and yes, there are defined phases that they go through. I just mentioned softwood lumber. There's a preliminary phase, and then there's a certain number of days before the final phase, and then once the order hits, there are defined time frames. And then after an order is issued, there's usually an annual administrative review, and they'll define an annual period of review where they're looking at that. So there are defined periods of time. Those cases remain open, and the only time they would really close is when there's a sunset review and Commerce actually determines the case to be, I think the terminology is revocated, or I don't know what.
Right, Commerce has what's called a sunset review, and then can revoke the order after making specific determinations under a sunset.
But that's usually at least 5 years from when the order was first issued. So you're usually looking at least a six-year cycle. And many times, even after the sunset review, they continue. They continue another, they determine that dumping is still occurring, and they would then continue for another 5 years, and so on. So hopefully that answers your question. What are the best practice steps for importers to ensure compliance? Should it be approached based on scope orders and subsequently HTS for risk evaluation? I can tell you from our standpoint and from when we did the webinar with Commerce, you cannot rely on HTS because the scope is broader. You have to rely on what the scope says and what the scope of the order is. And you can approach Commerce for a scope ruling. That is not something you can get for CBP. Do not confuse it with the binding ruling. You must get a scope ruling from Commerce to just determine whether your product is in or out of scope. I do know the Centers of Excellence and Expertise, if you call them for their specific industry, they can sometimes help you and give guidance on that. But you really have to go, you remember at the beginning of my presentation when when you get a copy of it, I mentioned how there was CSM messages being pushed out to the trade when there's a new investigation. Commerce in those new investigations and anything you can go and find on their site gives a very detailed description of the scope, and that must be what you rely on. Does anyone have any other comments?
No, that's true. Don't rely on the HTS. And one other potential red flag is that if an importer changes its import pattern to an HTS that's very close to what it was using before, that might be a red flag for misclassification if it just changes the last 2 out of 10 or 8.
Yeah, if you have any uncertainty, call the CLU, the call center, like I mentioned. Reach out to Center of Excellence or Expertise, one of the centers to help you. That is your best course of action to determine whether your product is in scope. Another question was, how can an importer get a declared non-reimbursement DEC ID? I think what you're talking about is for in anti-dumping cases, you need to show or get proof of a non-reimbursement declaration because that shows that you're not being reimbursed for those anti-dumping duties. And as a surety, we see this a lot of times. People don't get it, and that means when the entry liquidates, it'll be for double the anti-dumping duty. So if you're looking at a 200% rate, that goes up to 400%. So you can provide the non-reimbursement DEC at the time of entry up until liquidation to avoid double the duty, and you need to get that from your supply chain. They need to fill that out. Usually it's the shipper that you're working with, the importer, would get that as they're going through the process. Your broker can help you do that. Your broker can then track those certificates and do even a blanket reimbursement certificate in ACE. And it's important for you to get that to avoid a double duty situation in anti-dumping. It would not apply in countervailing duty, only in anti-dumping cases. Another question, there was supposed to be a final determination on 5050 series aluminum circumvention by the end of April. Can you provide an update on this matter? This is a question for Commerce. We will look into that for you and get back to you with a response. How do we find out if there is an open investigation? I assume you mean an open ADCVD investigation. If you go into the link that we provided on the ADCVD search page, you can search by commodity, and it'll show you any open cases for that commodity. You can go to the Department of Commerce website. We gave you a link, I think the ITC, where there's an open list of all the orders that are active. You can look there. So go, when you get a copy of the presentation, if you go to the end where I provide all those helpful links, you should be able to find a complete list there.
Okay. Yeah, I interpreted that as a HSI investigation, I thought, not necessarily a...
Oh,
Yeah,
maybe.
So
yeah.
That's what that was my thought.
We do not make HSI investigations public.
Okay.
So you would not know. There is no list
That's
published of open HSI investigations.
Okay. So let's see, we have some more. As a broker who has several customers that import aluminum extrusions, the scope of this case as far as unassembled kits and finished goods is not very clear. We have found it difficult, if not impossible, to get anyone to provide any guidance. We are told to submit a scope ruling, which is extremely time-consuming, and the responses often take close to a year or more. Any recommendations on who to contact to discuss further? I think, as I mentioned, that's really a commerce issue, and I don't know if you've tried calling the call center and then CBP.
Yes. Hello, this is a commerce issue. However, I work with U.S. Customs and Border Protection at the headquarters office, ADCVD, Crystal Oliphant. You can send an email to us, and we can coordinate that with the Department of Commerce, their CLU unit, and see if they can assist you.
Another question was how to determine the ADCVD rate of the manufacturer. Again, this is going to be outlined in the actual case. I referenced the softwood lumber case that just came out. It's going to stipulate what the rates are per shipper, and then if the shipper's not listed, they'll be subject to the all others rate. I'm not aware, as far as how that rate is determined, that is the process that Commerce goes through as part of their investigation. And it's based on how they complete surveys and provide information to Commerce to establish that rate. Does anybody else have any feedback on that? Or?
Usually the all others rate is just the average of all the calculated rates, a weighted average.
Right, okay. Okay. So according to what DOJ attorneys just said, there is no requirement obligation to maintain records longer than 5 years from date of entry, even for ADCVD entries.
Well, there's a regulation that says you need to maintain records for 5 years. There's also an independent obligation if you're aware that that information might be subject of litigation. There's an independent obligation not to spoliate evidence, and so that's a different obligation, but it's a very real obligation, just the same. And so, for example, after 5 years and a day, if a broker learns that records are relevant to litigation, possibly litigation against them, and they immediately destroy all of those records, at that point, they have a big spoliation problem.
Okay, and so the question here, too, also about paperwork, are you required to keep entry paperwork longer than 5 years for O3 entries? And the answer is no, there's nothing specific, but...
I'm not aware of any, but the customs people should have a better answer to that.
There's no regulation that stipulates it, but CBP...
I would think 5 years too, but I would have to get with legal just to make sure, look in the regulations and see if there's beyond 5 years.
I could tell you from a surety standpoint, we're not obviously regulated the way you are as a customs broker, but we keep everything for 7 years because even by usually simple state laws, but even that's not long enough for dumping, and so we do tend to keep our dumping paperwork until we know that it's liquidated and the exposure is gone. So that really comes down to a business practice that you decide in your operation. How can we get a ruling on a product that we keep getting hits on for ADCVD and we have proven there is no ADCVD for it?
request a ruling through CBP's Office of Regulations and Rulings. So that's if you want to get the specifics on that, feel free to email me, Crystal Oliphant, and I'll give you those details.
Okay, so for Robin, who had submitted this claim, we're going to get CBP involved to get you a little bit more information on how to get a CBP ruling to address this, right? Okay, all right. Has CBP ever seen Commerce take away separate duty rates? If so, what's an example of why?
I think if you're looking in the China category, sometimes specific exporters will get their own dumping rate if they can prove that they're not basically part of the Chinese government. And what occasionally happens during an administrative review, a producer or exporter might not be able to demonstrate independence from Chinese authorities. And at that point, it would become part of the China-wide entity and it would receive the China-wide rate, which is often much higher than the individual rates.
Okay, we have room for one last question before we have to end, and probably take this one because it involves the panel here. Can you explain the difference between commerce circumvention investigation and a CBP evasion investigation? You guys want to take a stab at that, or? A lot of looks around the room here.
Commerce Department investigation.
Yeah, they have anti-circumvention that they, yeah.
We can't speak on behalf of Commerce.
Okay. We're going to have to do some more research on that one because we need to get input from Commerce. So unfortunately, we have run out of time. I want to thank our panel for being here today, and if you can hear us clapping here in the room, thank you very much. Thank you for your time. And anyone who didn't get their question answered, we will come back to you with an answer, and we will come back with all of the Q&A in writing to be a helpful resource for you going forward. So thank you very much for joining us today. Goodbye.